Labrīt, dāmas un kungi. Доброе утро, дамы и господа. По-латински я знаю только 5 слов. Лучше по-английски. And you'll hear some beautiful English now from our colleagues for the next 2 days, 3 days, I think. Now, as our chairman has explained, I'll first of all tell you something about myself, and then I'll go into the subjects that I have gone over very briefly in my paper. I hope to entertain you as well as instruct you. But first, may I thank you, Chairman, very much for inviting me on this occasion. It's my 3rd visit to Latvia. My first visit was just after independence, literally within a month. I was asked to take law books from England to the Law Society, the equivalent of the Law Society in Estonia, Latvia, and Lithuania. I took a truck with books on the Estonia 2 weeks before it sank, and I went down through Estonia, through Tartu, then down to Latvia. And there was the new border control, with all the border officers in their beautiful new uniforms with the lion and everything. And the chief said, No, невозможно, your car is bad. I said, my car, I'd driven from England. And he said, no, it's forbidden. I said, why? He said, the steering wheel is on the wrong side. This is a circus car. I said, no. In England, we drive on the other side. No, you don't. So he telephoned his chief in Riga and confirmed that, in fact, the eccentric English did drive on the wrong side of the road. So all was well, but how much I enjoy being here, what a pleasure it is, and how things have got better and better. I cannot tell you, 20 or years ago, it was pretty grim, but now it's much, much better. So thank you for inviting me, and let's now get down to some work. I'm talking to you in my first paper about ADR, and ADR is Alternative Dispute Resolution. It is becoming more and more important, and it is now becoming a major item in IP litigation generally, and is considered in almost every case. My background is this. I was first a scientist. I read chemistry at Oxford, but I decided that I was no good at chemistry. So what do you do if you're no good at your subject like chemistry? You either teach or you become a lawyer. I chose the latter. And it has proved to be of great importance because of the main topics that I deal with as a lawyer. Patents is the most important. And although the science involved has advanced considerably since I was at Oxford, nonetheless, a scientific discipline is of immense use in all branches of IP work. So I approach what I'm telling you today mainly from the point of view of patents, but not exclusively. We also do, of course, confidential information. We do trademarks, obviously. We do designs. We do competition law. We do copyright in a big way. But I think Thomas Dillon will have a lot to tell you about that. He's the real expert on the copyright side. After 30 years as a practitioner fighting cases in London and also in other places, you remember the British once had an empire, and the result, or one of the results of the British Empire, is that the law system in many countries throughout the world is virtually identical to what it is in London. So one little advantage of being an IP man in London is that you get sent to the former British Empire. IP cases do not come up every day, and so when a specialist case comes up in, let us say, Hong Kong or Singapore, people from London generally go there to do the case. I was very lucky. I did a few cases in India, and from there they heard about me even in Pakistan. So I was called over to Pakistan, and then I was called in various other places like Hong Kong and Singapore and Australia. And it is amazing how uniform practice is, in spite of the fact that, of course, we now sing to a different tune, namely that of the European Patent Office. But nonetheless, the concepts are pretty contiguous. Now, what about ADR? Let me come to the point. This paper is largely concerned, or to some extent at any rate, concerned with the high cost of IP litigation. Now, as judges, and I think most of them are judges today, you will come across this, particularly in patent cases. Now, IP cannot, in my view, be a topic, a thing at law of the very rich only, or of the multinational corporation, who, as we know, have lawyers from wall to wall. No, it is for everybody. And it can go from a singer-songwriter, personal matter, to a major, let us say, petrochemical or biological patent case. Patent cases and IP cases are of very different sizes and lengths and of different complications. And in a moment, I'll have a look at some of the complications that cause a lot of trouble and a lot of cost. Now, as judges, it will be, I suggest, one of your jobs to try and make sure that cost is not a dominant feature in a case, because you will find, and it is true, I speak to judges here, that many litigants, in my experience, and I was a judge for 10 years myself in London, many cases are brought to shut people up. Do you understand what I mean? In other words, they have been brought to stifle competition. Don't let it happen. A big corporation can easily attempt to stifle competition by bringing a patent case. And indeed, this has been recognized for years and years, because in the British system, can I call it the common law system, we have an action for threats, unlawfully threatening people with infringement, which is considered, even in the times of Queen Victoria, to be so bad as to be a separate cause of action. Unjustified threats were and still are actionable, and an injunction can be obtained to stop them. It's to do with cost, and it's to do with the unjustified use of IP. Now, I want to go into costs. I put in my paper, Costs Bedevil IP Litigation. And my subject today will be, as I say, to a large extent from that approach. It'll also be from the approach of the common law rather than the civil law jurisdiction, which yours is. Remember that the British common law jurisdiction, although it may seem irrelevant to many of you here, being in the traditional continental system, It does, when you think about it, actually take part in almost half the world, from Australia, New Zealand, to our cousins in America, to obviously the United Kingdom and the Republic of Ireland in the EU, and Malta, and Gibraltar, and a lot of Africa, Canada, etc. So it is important, and the principles which emerge, which will interest you, I think, are general principles that can be applied by you as judges in both systems. And I base a lot of what I have said on personal experience, both as a practitioner and as a judge. Now, there are various forms of alternative dispute resolution, ADR. There is, and always and has been for years and years, the well-known process of arbitration. Now I have retired as a judge. We have to retire at the age of 70 in England, which I regard as a great shame. There's a famous patent judge in Victorian times who retired at the age of 101. And he gave his last judgment at the end of July when he was 101. And that judgment was recorded by a shorthand writer, of course, and is reported, and you can read it today. It goes to 15, 20 pages. And he died 2 weeks later. Never mind, I'm not encouraging you to go on working till you're 101. But in my time as a judge, I have had quite a bit of experience of the success of ADR, and I'll talk about that. In preparing cases, we have an early meeting with the judge. The parties go to the judge, and it is what is called a case management conference, or CMC, takes place. It is a forum for general discussion about the way the case is to be run. Pleadings start, of course, in the usual way. There's a writ, or summons, it's called various things now, and then in due course, when the case is framed, there will be a case management conference, and all kinds of things will be discussed. Now, when I was a judge, and I notice that my successors do it as well, we always raised the question of alternative dispute resolution, particularly mediation, for reasons I will come to. And I always had inserted in the order made at the end of the case management conference, quotes, I put it in my note, and the possible benefit of mediation as a means of resolving this dispute having been drawn to the attention of the parties by the court and or by the parties' representatives. This is hugely important. And I don't know, of course, a thing about procedure in Latvia, but I would recommend it to you as judges that parties must be told about the benefits of mediation or possibly of preliminary or early neutral evaluation, which I shall mention now. It is amazing the number of even professional people who don't think of it. And today, particularly for cases that are not worth a huge amount of money, but are nevertheless in the interests of justice, must be tried, must be adjudicated. Nonetheless, the question of mediation or early resolution or ADR of other forms must be put to the litigants. Now, arbitration I needn't say very much about. As I've retired, I do a bit of arbitration at the moment, both as an arbitrator and as a counsel and participant in IP arbitrations, and there are plenty of them. I think in your training, you probably know the advantages and disadvantages of mediation. One of them, arbitration. One of them is, of course, that the proceedings are private. Other people need not know about them. In fact, they do get to know about them because people talk, but the details never emerge. But remember, the result of an arbitration is similar to that of a court case. Of course, another advantage of arbitration is that the procedure is more informal. You're not bound by rules of the court or necessarily rules of evidence. It is for the arbitrator or panel of arbitrators to decide about that. And there are, of course, statutory limits. In most countries, there are arbitration acts. But subject to that, the procedure is much more open. But remember that in arbitration, the process yields a adjudicated result. The tribunal, or the arbitrator, if there's a single arbitrator, comes to a decision, just as the judge does in court. Contrast, ladies and gentlemen, mediation and early evaluation, or preliminary neutral evaluation, where there is no decision, particularly in mediation, there is no decision as such. People say, in mediation, everybody should be a winner. Now, after I ceased to be a judge, I decided to take some training as a mediator. So there are various places where you can do this. There is a centre in Geneva, which is run by WIPO, for whom Thomas Dillon works, and he perhaps will tell you something about it. An excellent centre for training. Training course lasts a couple of days. Unfortunately, unless you get someone kind like the chairman to pay for you. Sorry, Mr. Chairman, I didn't mean that. It does cost quite a lot of money, a couple of €1,000. But it's a good course. There are other courses. There's one in London to which people all over the world go called CEDR, C-E-D-R, which stands for the Centre for the something of Dispute Resolution. Anyway, I forget what it is. But it's a good training course. And when I went there and said, I want to do your course, the lady said to me, what have you been doing in your life? I said, well, I've been a judge. Ha! She said, you'll be useless. I said, I beg your pardon? You're going to ask me for several £1,000s to go on your course. You told me already that I'm useless. She said, yes, you're a judge. We don't want judges. We want psychologists. We want sensible people who are going to take a view which is not one-sided or the other, and etc. And I said, oh, thank you very much for these useful tips, but I'll still do the course, which I did and which happily I passed. But you'll see what I mean in a moment, because in mediation, which is what I'm really concentrating on, there are no decisions. It is a different outcome to that of court procedure and resolution, and different also to arbitration. Now, a short word on preliminary or early neutral evaluation. Now, this is often brought up. It's very rare that it happens. It's usually done by a judge, and it happens in certain cases only where there is an issue which really is short and is the key to the entire litigation. And a view expressed on it would probably put an end to the litigation. Let me take a patent case. You probably know, and if you don't know, I'm sure others will tell you soon, that a patent is a document which consists basically of three parts, usually. there's the description, there are the claims. This says, keep out, this is mine. And then in many patents there are drawings, illustrations of various kinds. Now, very often the real dispute in a patent case is in the claims. And you as judges will be asked whether, in a particular case, a particular item, which Australians call widgets, just for fun, falls within the claim. And usually there is one word or one phrase in the claim which is in dispute. And that is the issue. Now, if the matter is simply that, is this a barrel-locking, nut-retaining plunger, or isn't it? And that is the whole case. I say a barrel-locking, nut-retaining plunger from my military service because it is a vital piece of a machine gun right in the middle, which you must never, never lose, or else you'll probably be put in prison. But never mind. Many cases turn on a single word or phrase or adjective. And it was thought that it could prove useful if a judge, having been introduced to a topic, expressed a view about that word, what it meant, in context, always in context. It also applies to some extent in design. It also applies to some extent in trademark work, and we have a common law cousin to trademark in common law countries called passing off. Is confusion likely in this particular circumstance? Is this word or is this emblem likely to be confused with another one? Now, it was thought at first that it could be useful and save a lot of money if a judge expressed an early view after listening to counsel, say for a day, not much more, and the judge would say, well, I think this must be a barrel-locking, nut-retaining plunger because it's yellow. Well, unfortunately, it never got off. So let us now, although being aware of preliminary or early neutral evaluation, which can be useful in mediation involving medical or other building, for example, contracts, is pretty useless in IP work. Unfortunately, it is the nature of the animal. You've got to go into the thing in some detail. So that turns us now finally to my real purpose, and that is mediation. Now, mediation is a form of negotiation between parties in dispute which is facilitated by a neutral third party, the mediator. A qualified person is the mediator. Now, the mediator needn't be a lawyer. When I did my mediation training, there were 2 doctors. Or one was a surgeon, retired surgeon, one was a retired doctor. Frequently, psychiatrists do this. Because, of course, there's a lot of medical negligence work. There's a lot of work in the building trade involving negligence, involving bad building or whatever. And so the mediator will be a trained person, but he needn't be a lawyer, and you should bear that in mind when you order mediations, or whether, I think it may not in some countries be possible to be a mediator and also a judge, separately appointed, of course. And remember also, and I'll say it at this stage, that mediations can take place without the intervention of lawyers. Usually, lawyers are present, and they do help the judge a great deal, because if you don't have a lawyer present, very often those arguing their cases in a mediation will come unfocused, and they'll talk about silly things and emotional things and this, that, and the other. And it's the job of the mediator to say, no, we are sticking to the point. And it is usually the case that lawyers are much better at that sort of thing than laymen. They keep to the point, and they keep the judge, or the mediator rather, engaged. So mediation is a process wherein there are, as I said earlier, two important distinctions from other forms of ADR. No single winner emerges, and there is no decision. The word I used a moment ago was facilitates. The mediator is a facilitator. Terribly important that you should know this. And very often as judges, you can see very quickly where the real dispute is. And you may even say to yourself, oh, how silly this dispute is, if only they could put their heads together and solve it in a sensible way. And this is where the skill of the mediator comes in, and we'll see it again and again. A good mediator can do all kinds of things a judge can't do. Sometimes a judge can also be a good mediator. And you should be aware of that when and if you order a mediation. Also, I don't know if you can in Latvian practice. In some countries you can. We're now getting to the stage in Britain where judges can actually order mediations. I think in some commercial cases, according to one recent decision, it is possible to do so. I know in the commercial court in Australia, for example, a judge can order a mediation. And in his order, he will stipulate a time within which it is to take place. And we'll deal with timings in a minute. So, in a successful mediation, both sides are in truth winners, as I said earlier. And what emerges is the drafting of a legal agreement recording their agreement at the end of the mediation, which has legal effect in the law of contract. Now, since this form of ADR is relatively new to IP disputes, and in the light of the potentially high cost of such disputes, it has become the most promising form of ADR for IP practitioners. And in my experience as a judge, it was just beginning to take off. And I'm happy to say that since I retired from being a judge, it has found more and more use. And more people are turning to mediation. And I, as an ex-judge, am now picking up work as a mediator. And it can take all kinds of disputes, every aspect of IP, except one. And I'll come back to it as well. The one aspect is this. As you know, a patent, a trademark, a design are monopolies granted by the state. The one thing a mediator can't do, and of course neither can an arbitrator, is to cancel a patent, a design, or a trademark on a ground of invalidity, which is 99% statutory. That can't be done. Mind you, that can be of benefit, because sometimes two people who are fighting under the influence of a mediator can say, come on guys, let's think. There are competitors to both of us in the market. Why don't we get together, form an agreement, and just keep other people out and not attack the patent or the trademark or the design? All right, you've got some important, what's called prior art. You may have heard of this. The public, other people in the trade even, may not know about it. Let's just shut up, not attack it. So there can be benefits in validity not being available. That is the main disadvantage. There is a directive, 2008/52/EC, which is called the EU Mid Mediation Directive, it is of some interest, of limited interest, but basically it reflects more a philosophy and a trend than a working reality. Mediation, in fact, is the subject, that I have said, of dedicated training programs now. And if you're interested at any stages of your career, I would recommend that you do the training. The training is interesting. It's not a lawyer's training at all. It's different. And may I say, you can get paid quite well as a mediator. Let's look at cost realities. There are some basic practical questions which I believe must be looked at in IP work as being prime generators of cost. People want to know at the outset, how much will it cost? Well, now, it's awfully difficult. How long is a piece of string? The trouble is that a lot of IP cases are worth a lot of money, and therefore, more than many other cases, they go to appeal. Then what happens? Sometimes there are 3 stages of appeal, and as in the United Kingdom. First judge, Court of Appeal, Supreme Court. Of course, you've got to get permission to go up, and that acts as a filter. I'm not saying all cases go on up. If you start from the Patent Office, you have yet another layer. At the EPO, you have 2 layers. You can intervene by arbitration or by mediation at any stage. It can be mediated. So a client will often ask, how much is it going to cost overall? So then you've got to go into some detail. How strong are the parties' cases? In ordinary litigation, in court, you have validity as well, and the cost of fighting validity can be higher than the cost, frequently is, usually is, higher than the cost of infringement. Because I'm sure you know, many of you, that in IP litigation, particularly when you have patents and designs, there is a dynamic. There is infringement, and there is the reply, but your right is not valid, but your patent is invalid, and there are statutory grounds for saying that it is invalid. Prior publication, obviousness, inutility sometimes, insufficiency in others. So in normal litigation, it can be a hell of a costly exercise. I'll look at some of the features in a minute. Another factor that you must be aware of, in ordinary IP litigations, look at it in a moment, there is the expert. Always there are experts. Now, what do you think about experts? If you've had any experience with court experts, the first thing you'll know is they cost a lot of money. If you think a professor is costing a lot of money, wait till you see the costs of a person called a forensic accountant. Let's say you win the case and you have an inquiry as to damages. And the damages are not agreed. You can mediate, of course. Many do. Many look at the cost of the forensic accountant and say, my goodness, this man costs even more than the lawyers did the first time, because it is a very specialist area of accountancy. That is another generator of costs. And there are also expert interventions in trademark cases and other cases as well. There are also questions like preliminary injunctions, which I shall be talking about tomorrow. Almost always, not always, but almost always, in practice, when an infringement is involved, save where there has been an inordinate delay, the parties will be thinking of going for an interim or interlocutory or emergency injunction. That is a separate cost generator. It is not meant to be a mini trial, but often is, and it can be very costly, particularly if it is preceded by an emergency procedure, such as in the common law jurisdiction we call what used to be called an Anton Pillar order, or a search and seize order, or in the French-Belgian jurisdiction, saison contrefaçon. Yes, exactly. And saisie, not saison, sorry, saisie contrefaçon, which again is an extra factor to bear in mind. There are other orders that you can go for in an early stage. There's one which is much used in the common law jurisdictions, named after a case called the Norwich Pharmacal Order. Might mention that tomorrow. That's when some third party, an innocent third party, gets mixed up in an infringement, willingly or unwillingly. It came from a famous case in which a government department, at the end of the year, published its statistics. And it showed, under a pharmaceutical heading, a particular chemical which had been imported to a large extent, subject of a patent, but the patentee knew that it had never sold that much. And it said to the government department, tell us where you got this information from. And they said, no, it's private. And so the government remained silent. But the patentee challenged the government department and said, you've got to tell us who imported this infringing product. Because it's our patent, here it is, it's valid and extant. Could be challenged, of course. So that's a sort of order that you can get sometimes. Procedures requiring the divulging of commercial confidential information. Again, that can give rise to quite expensive arrangements involving what's called confidentiality clubs. And in common law jurisdiction, you've got to be careful of provoking satellite litigation by statutory actions for what I called earlier on unjustified threats in certain cases. All these are potential sources of cost. In patent cases, the role of experts, claim construction, the validity of the patent in suit, assessment of damages, delay having regard to the choice of experts, and voluminous disclosure of documents quite often, the disclosure of sensitive information, and problems concerning the patentability of computer-implemented inventions, which are a favorite for giving rise to long and complicated discussions. In design cases, the sheer complexity and variety of the legislation covering designs can give rise to long and expensive argument. There is always argument with overlap with copyright and the legal effect thereof, and in community design cases, delay in the disposal of appeals from Alicante at the European Court of Justice. Trademark cases, again, the complexity of the law, particularly in the right of recent ECJ decisions, about which I shall make no critical comment, but many have, because they are not all consistent. The more frequent submission of expert evidence from, for example, statisticians. You remember Mark Twain, there are lies, damn lies, and statistics. I have been in a case in which one lot of statistics were produced as a result of what's called hall surveys. Now, hall survey is when a man stands outside a supermarket and says, excuse me, would you look at these two cards, and that sort of thing. And then the results get fed in, and then there are arguments from the other side that the statistical method was not right. I was in a case once in which the statisticians ended up invoking Fourier analysis, mathematics, to try and show that one was wrong and the other was right. And in no time, from a simple decision, we got into a complex field of mathematics. Community trademark cases, I've already mentioned, and also there is the involvement of possible criminal procedures as well. In copyright cases, very often there are heavy cost difficulties involving authorship, ownership, and title. There are also legal problems in and out of copyright. I did a case when I first started involving Charlie Chaplin films. I cannot tell you how difficult that was because the United States was not then a member of the convention. It required publication in Ottawa or somewhere nearby in Canada to get it into the convention. There were endless disputes about when things were first published because there was a timeline. Searching through newspapers for advertisements of film showings. It involved a lot of money. Cases involving computer software. Experts often give evidence to prove copying from particular lines of instruction in voluminous incorporations of software. Whether it may commercially be more sensible to take criminal action is another thing, and whether copyright is the best protection available to protect new technology. All these can be considerable sources of cost. Trade secrets, there's always a need to identify with clarity the trade secret in issue, usually to the defendant's rival, and often, in some cases, no, not often, in open court. And there are always problems with ex-employees. Ex-employees love to run off with their employer's secrets, and catching the ex-employee can be difficult. The ex-employee will normally tell lies. People in court very, 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 very often tell lies, and you as a judge will have to sort out who's telling the truth. It's not easy. And then I should mention also some of the rarer forms of IP that you'll be dealing with, collecting societies. Now, I don't know how important that is here in Latvia, but collecting societies in the United Kingdom are very important. They bring cases, they have cases brought against them. There are disputes between the collecting society and authors of copyright works. I was the chairman of the Copyright Tribunal of the United Kingdom for 10 years. Huge cases that go on for weeks. Comparable rates of revenue, comparables in different countries of various, it can be hugely expensive. The sheer number of parties and lawyers likely to be involved in these collecting society cases are enormous. Now, all of these matters should be taken into account when you as a judge are faced with a case that you think should go to mediation. Say so. told them, have you thought of mediation? Well, yes, no, I don't know. But then you might as well mention to them some of the things that I'm talking about. Talk to them. Have you thought of the cost of this? I mean, you're perfectly entitled. Of course, we don't want to infringe anything in the European Court of Human Rights area. You're entitled, obviously, to enforce your rights as a citizen of the European Union, but at a cost. Now, let me move on to the question of specialist IP courts and how that fits into this. In some countries, I don't know that you have it in this country, you have specialist IP courts. There is a tendency for more and more specialist IP courts to be created. I was involved in the creation. We've had them in England since 1949, with a specialist judge and a specialist statute. There are advantages in specialist courts, and there are disadvantages. There are specialist courts that are good, where you have a judge who is scientifically qualified and who knows what is often regarded as being a highly specialized area of law. He can or she can dispose of cases quickly and efficiently, but not always. And also, when you practice before the same judge day after day after day, as a lawyer, you sometimes get a little fed up with appearing before the same person all the time, because you know the sort of way he thinks. Mind you, that has advantages, but it also has disadvantages. And indeed, in the case of my first chambers, my head of chambers appeared so often before our first patent judge, a man called Lloyd Jacob, that he drove him to retirement. He said, "I'm leaving." We said, "Oh, Geoffrey, why are you leaving?" He said, "I can't stand appearing before the same judge every day." And so he left. So these are things you have to bear in mind. But on the other hand, on the whole, specialist IP courts have developed speedier procedures, and procedures in which the possibility of pushing in an IP mediation is there. I have had personal experience of these problems, and you can certainly ask me questions about them. But in the cases, many cases in which mediations have occurred, sometimes quite suddenly, the first thing in the morning, case is going on, counsel gets up and said, "Look, I've been talking to my opponent. We've decided to mediate." Fine. And as a judge, you'll say, "Good, mediate, but you must always set a timetable. I want you to report back to me in 1 month and tell me what's happened." Because sometimes, of course, mediation lawyers will do anything to win their case. Sometimes they'll say, "I want mediation." Very good, fine. And you'll find that 6 months later, nothing has happened at all. In other words, it's a stalling procedure. Or there are other little ways lawyers have of messing things up. So keep an eye when a mediation is declared, must keep an eye on how it's going. Let me look at some more general advantages. A good mediator will, as I've said, assess the psychology of a situation so as to help overcome emotional blockages, personal enmities, and the influence of the quality, aims, and dynamics of the negotiating process so as to achieve better outcomes. And I look at some other personal advantages. I've dealt with cost saving. Remember also hassle. When you've got people appearing before you, it's usually commercial, And most managing directors regard IP litigation as, if I may be rather rude about it in English, a bloody nuisance. It takes time, often a lot of time. It takes management commitment, and it takes money. They don't like it. So it is an advantage of mediation that it avoids hassle, uncertainty, anxiety, and the commercial downtime which is associated with the trial of IP matters. No appeals with mediation, that's it. And as I said, normally a high proportion of IP cases go to appeal. Anti-suit injunctions involving the uninvoked arbitration clauses in licensing agreements don't arise. Judge risk and the inevitable uncertainties of litigation. I'm sorry to say it, but as judges, people will form opinions about you in the legal profession. Oh, Mrs. Justice so-and-so. Oh, dear, dear. She's a Friday judge, I'm afraid. She never reads the papers. And, or some other criticisms will be made of you. Don't worry, but mediation avoids all that sort of thing. Of course, mediation is another good way of settling international disputes. A lot of IP work is international, as I'm sure you probably guessed. And sometimes we have parallel litigations in different countries involving the same subject matter, and of course, different outcomes. Famously, there was the Epi Lady case, the case involving the Israeli invention for removing hair from the skin, the rolling spring and the rolling piece of rubber. And this led to litigation in all the major jurisdictions and a 50-50 result that was different in each country. All that is avoided. Mind you, we're getting, hopefully, if the German Supreme Court, Constitutional Court rather, makes its mind up about the Community Patent Court, then we should be able to get around some of that in the future. But at the moment, it's very much there. Resolution of the parties' collateral disputes, I mentioned, and also a much wider range of possible solutions. You see, a mediator can suggest viable, possibly viable, or realistic at least, solutions to disputes that a judge could never do. That's a real advantage. And sometimes, as judges, you'll be asked by litigants, particularly in the United Kingdom, we have litigants in person. I don't know if you're allowed to do that in Latvia, but ordinary people needn't have lawyers. They can go to court without a lawyer and address the judge. Is that possible? Anyway, these are the things that, as a judge, you can talk about. And generally, it's much faster. As I shall say in a few minutes, I make my mediations last no more than 1 day. It's over. The drafting of an agreement, of course, could take longer, but the essential hearing, 1 day. Of course, it's not a strict rule. There may be occasions in which the subject matter calls for a more extended hearing. No inquiry as to damages, and as I've said, win-win situation is an outcome. It may catalyze the formation of new commercial relationships to the exclusion of third parties, cross-licensing, all that sort of thing can emerge. These are real commercial benefits. And there'll be no inquiry as to damages, as I've said. remember also that what goes on in a mediation is always without prejudice. If the mediation doesn't work, then you can go back to court. But what happened in the mediation, and I'll come to the mediation agreement in a moment, what happens in the mediation is confidential and without prejudice to what happens in the future. Of course, it's true that you can't keep out of your mind what you've heard, and that can be of an advantage as well, but it can't be used. Even an unsuccessful mediation may lead to a better and more realistic mutual understanding of the parties' position and what's really an issue and what you can give a miss to. Now, disadvantages. It takes the agreement of the other side to set up a mediation, and very often a good deal of time is wasted in arguing about this. Mediation should be attractive to people pretty quickly. And if they're arguing about whether to mediate or not, forget it. They generally won't bother. It is no or little use thinking of mediation in cases of emergency. I mentioned, and I will mention in my next talk on injunctions, that IP is full of emergency injunctions, very often to stop people, for example, at exhibitions, exhibiting what is regarded as being an infringement. And there you will sometimes need an emergency injunction from the judge, sometimes what we call an ex parte emergency injunction. And that means an injunction obtained without the other side being there initially. That, of course, is not appropriate when you're thinking of mediation. Not much use if you want what we call at the patent bar in England a trophy, a cup. So you can put in the trade paper, look, I got an injunction against Mr. Dillon here, and I want you to know this is the order the judge made. Beware, if you do this, you too will be in court and will get an injunction of the same kind. They're called trophies. Very often they occur after a trade fair, like, for example, let's take the famous Nuremberg trade fair for toys. It was one of our things we used to say, November, Nuremberg is coming up. And always the Nuremberg toy fair produced a crop of infringements. And barristers' chambers, lawyers' chambers used to be full of little toys, plastic dogs, dolls. You can't imagine the sort of things that were there. And this is all to do with a request for interlocutory injunctions. You get one, you want that to kill the lot, give it a lot of publicity. It may be unattractive to a party seeking summary judgment. Now, what is summary judgment? That will come to you. I'm sure there's a procedure for this in Latvian procedure. It is when a party says, good Lord, they're not really asking for an injunction, are they, to stop this? But this is a yellow one, and they're asking you to stop a green one. They're saying yellow is green. Mad. So you go to the court and you try and what's called strike out the other person's case by means of a summary judgment. Now that does not mean a mini trial. It means saying to the judge, this case is hopeless. Mind you, that is usually done by the defendant. You say to the judge, please strike it out, it's hopeless, for the following reasons. The plaintiff or claimant can also do the same thing. He can say, this defense is pretend. There's nothing in this defense at all. I want judgment now. But of course, this is not suitable for ADR at all. Mediation will not be of interest where publicity for the litigation is actively sought by a party, for example, in class actions, or where a revolutionary product makes its first appearance on the market. I told you already it is irrelevant when the real purpose of the litigation is to revoke a piece of IP, because that is impossible. The principal and greatest disadvantage of using mediation to resolve a dispute remains that, in my view, of being unable to cancel or revoke the IP in question. Also, finally, it is worth mentioning that from time to time, mediation is subject to abuse. I'm afraid it's a fact of human nature that sometimes people bring mediations to find out about the other side's case. I had a mediation very recently in Birmingham. It was on a Friday. It was raining. And it was going wonderfully. It was a fight between two Indians. They were both related. One was a lawyer, and the other was a lawyer. And they had the same family name. And they both lived in the same area. You can see what's coming. And one was called something something, and the other was called something something. And they were both very similar. Not surprising, they were in the same family. Now you can see the sort of dispute. And it was going very nicely, and we were getting somewhere, and there would be a new email address, and he wouldn't use the first name, and all kinds of things. It was going really well, and I was looking at my, I was thinking, wonderful. I shall be able to take the 6 o'clock train back to London. And the rain was still going on. And I said, right, well, there we are now. Let's put this into an agreement. Suddenly, the claimant stood up, and he began shouting. And he said, now I've found out what my cousin is doing. He is an evil man. He is this, that, and the other. And I know God will damn him, and blah, blah, blah. It went on. I thought, oh, dear, no. And so nothing happened. We all went home without an agreement. Fortunately, I was paid, however. So therefore, you have to be careful of that. Now, I see time is marching on. Let us just do some methodology next, because how do they occur? Well, it usually happens that the judge perhaps might make a mention of it. The two legal advisors may get together and say, by the way, I noticed that the judge suggested we try mediation. Should we just talk about that? And it leads to yes. And the parties get together. They inform the court in writing that they're thinking of mediation, that it is their intention to draft a mediation agreement, and a mediation contract is drafted. Now, the contents of the contract usually should be done by a legally qualified person. Who will be the mediator? Now, I, as a judge, used to keep a list of mediators. There's nothing wrong with that. Anyone can put their name on the list who feels they're qualified, and I would hand the list out. Or, I would say, down the road in London is the Chartered Institute of Patent Agents, which is the trade association for patent agents, or the Chartered Institute of Trademark Agents, same thing for trademarks, or a list of specialist solicitors. And there is an Institute of Arbitrators, which has a similar list, and there's now, I believe, an Institute of Mediators with a list. So you can, as a judge, give people lists of people who are suitable as mediators. Now, it's for the legal advisors to find the right mediator. Cost, of course, comes into it. 99 times out of 100, the mediator's costs are shared 50-50. Get in touch with him or his clerk, find out how much he got. Oh, far too much, we don't like him. We'll try somebody a bit cheaper. Oh yes, but he doesn't do agricultural cases, he's a specialist in computers, etc. So you find a mediator, just one. Ask if he agrees, and then he has a contract, again drafted by the parties, which stipulates dates, times, etc. When the mediation is agreed, very often there's a meeting between the parties, then the following happens. Each party prepares a short summary of case, which is presented to the mediator and to the other side in advance. The mediator normally is an informal procedure. The mediator introduces himself, and if any of you are thinking of being mediators, I will give you one piece of advice. Always keep smiling. Smile. That's it. Just as I believe with schoolmasters should never, ever smile, mediators should keep smiling. Always charm, always pleasant, always doing his or her best to see a good conclusion to the matter before them. He will introduce himself to everybody in a friendly manner and explain how the mediation will work. The mediator usually reiterates the absolute need for mutual confidentiality and addresses the issue of without prejudice and any other preliminary observations, and also the question of timings. What happens? Because in a mediation, you get the real people. There they are, looking at each other the first time. So what do? You say, right, claimant, you tell me in your words what you're complaining about. And I've done 1 or 2 mediations, it's almost comic. The managing director stands up and shouts at the other, like this, you see. And then I say, well, thank you very much, Mr. So-and-so, most interesting. Now, Mr. So-and-so, you tell me, he's a dreadful, he did this, he did that, he did the other, blah, blah, blah. And the psychology is really much more interesting. You can't do this in court, but you can in a mediation. And it has a wonderful effect, because you can actually shout at the other side in a moderate way. I say, well, thank you very much. Then the next stage is, what? Do you remember a man called Dr. Kissinger? Who remembers Dr. Kissinger? You remember Dr. Kissinger. Dr. Kissinger, I believe he's still alive, was a man who worked at the time of Mr. Nixon. And one of his favorite techniques was that of shuttle diplomacy. He was a man from a town in East Germany. And he came to the United States and became a law professor at Harvard, and then later a quasi-politician. I hope I don't injure his reputation. But he was very skillful, because what he did was he went back and forth between the parties. And that is what the mediator does. He shuttles. Each side goes to a room, and the mediator shuttles back and forth between the two sides with a big sheet of paper, clipboard or whatever, with the other side's proposals. And this is where his or her skill comes in. Because this is not a mini trial. This is an exercise in trying to get the sides to agree an outcome. So you say this, you say that, you say the other. I'm not to say that under any circumstances. Okay, I've noted that, blah, blah, blah. And then you put it to the other side, and they say, yes, we agree to that. They argue, a bit of argument. Well, number 3, okay, if that's going to be the real sticking point, we'll agree to it. And you would be amazed what happens in mediations. People really do make progress. They drop silly points. And as a mediator, you're perfectly entitled to say, you're really saying that blue is green? I really don't think the judge will take that, you know. But there it is. If you want to persist with that argument, you know, do it. What do you think? So, well, I don't think blue is green, but it's up to you, you know. So just persist, and this is where being a psychologist, as well as your other qualification, comes in very handy. Common sense. So it goes back and forth, and it is what the Americans call caucusing. I don't like the word, but it is what Dr. Kissinger did. And you will be surprised at the times that shuttle diplomacy is successful. If it is successful, the mediator will at once prepare heads of agreement. You can adjourn the thing for a while, go and have a coffee, whatever, and he will prepare heads of agreement. Now, he says, now this is what I have, and he goes back and forth again. Here is my list of things that I think we've agreed. Is that correct? Yes, yes. Well, not quite. I wouldn't put it like that. Number 4. Yes, yes, yes. You go to the other side. How about this? Yes, yes, yes. And you knot together, it doesn't take too long, the bones of an agreement. Bring the parties back together and read out what's agreed. Anyone disagree? Speak now or forever hold your peace, as they say when you get married. And you would be surprised at the success rate that we have, even in IP cases. I can't give you a percentage, because I don't believe in that sort of statistics. If the mediation is unsuccessful, the parties may, of course, continue with their litigation. Confidence will, of course, be maintained, and the court will not investigate why the mediation was unsuccessful. The question of the costs of the litigation may, however, be raised with the trial judge if, say, a party unreasonably refuses to mediate. Unreasonably. Nowadays, in UK and Irish practice, there is a discussion at the end of the day about costs. And each party presents a schedule of costs. No longer is it the case that the winner takes all and the loser loses all. Oh no. You look at the issues, you see which issues won the case, which issues were lost, but nonetheless the case was overall won, or whatever. And the existence of an attempt to mediate, usually, or rather not mediate, is one of the matters that the judge will take into consideration with some caution. Of course, there could be a second attempt at mediation, and sometimes there is. If the mediation is successful, the mediator will at once prepare heads of agreement, wherein the heads of agreement are recorded. And as I say, it's put to the people involved for assessment. And then an agreement is drawn up. The parties sign the agreement, the mediator signs the agreement, and it works as any other commercial contract. May be enforced, there may be a breach, but in general, as far as I'm aware, they are remarkably successful. Now, some final thoughts, because I see, Mr. Chairman, time marches on. I think it's 11:30 now, 11:20. I don't believe that in IP work, mediation has become nearly as successful or important as it should be. And I would commend to you, as judges, in court, giving a shove to people, give them a push every now and again. Have you thought of mediation? Why not? Also, between ourselves, as we're all judges, it saves you a certain amount of work. But try it, push them, because it's taking place now in the IP world all over the world, particularly in America, where, of course, litigation costs are simply outrageous. There are no Americans here, I think, no. Where litigation costs can become outrageous and almost punitive. It is readily available. Facilities are available in association with all of the major UK courts. In some cases, for example, family courts, domestic courts, there is actually a conciliation and mediation service attached to the court. As you can appreciate, in family disputes, mediation could be of even more use and is frequently used on a daily basis. And it's all happened in the last 20 years. I've seen it happening. You've got to get a good place to have the mediation. You need a proper room with tables on either side, table for the mediator. I mean, it seems obvious, but they are very important. You need rooms for the shuttle diplomacy, the Dr. Kissinger stuff. You need facilities for, let us say, coffee, toilets, all that kind of thing. So some thought is required to set up a good mediation locale. And there are people who hire rooms for this purpose, or many lawyers have rooms. Some courts even have mediation room. There is one in London. Some lawyers' offices are adapted for that purpose. But it's still, the amount of mediation is still sadly small. In my chambers in London, there are, so I'm told, less than 25 IP mediations per year. The Intellectual Property Office, let's say the Patent Office, has expanded in the United Kingdom. It's in Wales, which is one of our provinces, is in fact also offering a mediation service, not much used. I don't know how much it's used in Geneva, but perhaps Mr. Dillon will tell you a bit about that. So procedural progress has been made with regard to costs in IP, admittedly, and generally we don't have the sort of outrageous costs that used to happen. For example, in patent cases, when I started, almost always there were experiments. My goodness, how much those cost. Sometimes when experiment would take place in the United States, an experiment in reply would take place in England. Then you go back to the United States. I remember once in a famous case involving a microporous surgical tape, we had to look at over 2,000 scanning electron microscope pictures taken at the McCrone Laboratory in Chicago. And during the course of this, it was snowing. And during the course of this, I walked out and looked in the window, and there were 20 lawyers fast asleep and 2 scientists on a scanning electron microscope saying, that one, picture, that one, picture. And that was costing how much a day? Unbelievable amount. Well, we have saved a lot of that because now you don't, in our system, have experiments of choice. You have to get permission. Progress has certainly been made on reducing costs, but there is still an inherent cost problem in IP. And that's, as judges, what I think you've got to tackle. And one of the ways of doing it is with mediation. I don't think the potential has been fully exploited. And finally, there are 2 things you should know, and this is my own thought. One, a bad agreement is usually less objectionable than a bad judgment. Now just think about that. A bad agreement is less objectionable than a bad judgment. The other thing is this. You may find ADR is not popular with lawyers. An American lawyer once said to me, when I was extolling the benefits of ADR, he said, "ADR," he said, "astonishing diminution in revenue." Thank you very much, ladies and gentlemen.
Thank you.